court generally, and let the that is where the lawyers also chop.
Again.
So if you don't know the lawyer, you go to executive court. Then you get technical knockout.
No, I think you should still leave it at the court. you see, again, you never know when other courts will be given the mandate to be part of it. So for now, it is the court.
The court. So leave it at the court. The courts will be fine.
Not the court. The High Court. Prohibition of grant of fosterage for LGBTQ persons.
I think we also do the same.
So adoption and fosterage.
So we'll add the last testing of alien sexual relations.
So now you may want to take note of that. Okay. Duty to report and the prohibition.
There's a hand here.
I'm just bringing something. Sorry, looking at the 14 and 15, I think they are all geared towards the best interest of the child. Looking at it in respect of adoption and fostering, can we bring another clause or something in respect of custody, where the court will take into consideration the status, yes, of in issuing, custody orders? Because you see, the all of them, we have, it is three: either adoption, fosterage, or custody. So then we will make it mandatory if it is established that a party, after the dissolution of a marriage or whatever, it is established that one party is, into those prohibited acts, then the court would take decision on making sure that the child doesn't.
You mean when they appear?
In the custody.
Yes, custody. When the court is making custody orders, because we have looked at adoption, you've looked at, and these three things are
adoption and fosterage.
Yes, but I'm saying that if you can add a provision in respect of grant of custody,
it means the child is already the person's child. Is that not the case?
Yes. So if you see that when the court is making orders in respect of custody, the court looks at the best interest of the child. So, yeah.
Chairman, I think that, and I've just done a bit of consultation with Doc and Senna. Doc, Chairman.
Yeah, please go ahead.
I think that the point Fifi is making is one that we should be able to look at. Is adoption, fosterage, and custody. And at the surface of it, you may say, but if the man and the woman are married, how then do this come in? But maybe the reason for the custody battle arising is from a divorce that is premised on the fact that the woman has filed for divorce because now she's realized that her husband is gay. And like we were told, they are married men who are engaged in this, and so that becomes the reason. Or the man is asking for custody because he's divorcing his wife, who he's found out is a lesbian. And the fear is that if you leave that girl child with the mother, that ideology may be transferred. So it's just to say that the court, in determining custody, may take into cognizance any of this if they may arise. So that's why we can leave for Senate to draft. But I think the principle is to have anyone
custody.
Yes, in respect of custody.
Prohibition of grant of custody for LGBTQ AP+ persons, and then we'll frame it along the issues of granting custody if the custody battle is premised on any of,
and it is established that
one of the parties in the custody battle is one of this.
Very well. Vice Chair.
Thank you, Chairman. I think that I also associate myself with those submissions. But just to add that in the issue, when it comes to custody, that one can be granted by even the circuit court. So then the issue of the court being the high court should be looked at. So that
we haven't defined it as the high court. We just left it as the court.
The court.
That's why Chairman said
That's why I'm saying you should make it a court.
Because then if it is the court, it will be interpreted to be a second
Don't put the high court.
court. Very well.
So I think we'll introduce a new.
Mr. Chairman.
On a new.
Yeah, Mr. Chairman. When it comes
because if
to
you now descend to
so
custody,
I
custody is not only with the high
I
court.
tend to agree
Starts
with the
from there.
sentiments that have been raised by Honorable Fifi Bachman, except to say that when it comes to custody issues, the court has wide jurisdiction, and the jurisdiction of the courts is to take into cognizance anything that will inure to the benefits of the child. And so you may have parents who are separating, and the court may not even give custody to the one who is more affluent than the other, because it is not a guarantee.
It can be a lifestyle.
Exactly. It's a lifestyle issue. So normally what the court does is to, on the case-by-case basis, consider what is in the best interest of the. So right now we may be legislating the discretion of the judge. And so if we leave it this way, to the courts has so wide jurisdiction and discretion to proceed with anything. But this could be a guide, especially if this law is passed. The judge will take judicial notice of the content of this law and decide on custody matter. So even if we don't state anything to that effect, the law will still, be adhered to. Yeah.
The court will be guided.
Well, so I think the court is already guided in terms of custody. And the fact that this law will exist.
Mr. Chairman,
Yes.
humbly, the court is guided already in the grant of fosterage and in the grant of adoption. So if we are looking at that in that state, then it means that we won't go in even in respect of those two. I am humbly praying that because of practice, Mr. Chairman, you've seen that my submissions are because of my active practice. I do lots of practice. That is why I'm pleading that if we have brought in adoption and fosterage, let us add custody.
Yeah, custody may stand on another leg. In the case of adoption and fosterage, these are stuff that are not related to the persons. Custody is different. These are biological kids in many cases of the parents. Yes.
I just noticed something from this discussion. Actually, the amendments to the Children's Act on adoption do not allow a person of same-sex orientation to apply. So I think instead of getting to the court even, at the stage of application, so instead of saying a court shall not grant, then you want to limit it to the application stage. Because they already in the amendments, and I was privileged to be part of the team that worked on it, a person of same-sex orientation cannot adopt a child in Ghana. Yes. Oh, the amendment, yes. It was passed, yeah, when Honorable Oyelita was, Oyebampoado was
Yes,
minister.
so the Amendment Act, yeah.
Yes, the amendment then. So we may not even get to the court at all, because I just realized fosterage at Department of Social Welfare. So you could still leave 14 within the remit of social welfare.
Okay.
Because that's where the adoption secretariat.
That will change 15.
15, yes, shall not grant an application for fosterage.
Fosterage, yes. Okay.
Yes.
Then with custody, I think we can leave custody as it is. The courts can use their discretion on the basis of this piece of legislation. No, on the basis of this. Yeah, the courts can be guided as to how they want to.
I also agree with you.
Vivi, but you have a valid
Because
point.
discretion is a discretion. A judge will say that I've granted it. If you like, go on appeal. Based on many things that influence the discretion.
Well, should we legislate that? Custody. I think we should leave that out for now. If there's need, we can always come for amendment. As time changes, we can come for amendment to if there's need. Now, the last one is on 16, and that has to do with a duty to report and the prohibition of extrajudicial treatment. Yes.
16.1, we think that a duty to report should not be made mandatory.
Yes.
It should be, so if you make it mandatory, for instance, in the context of, for instance, public health, again, come to public health system, it will undermine confidentiality, and it may leave room for people to be fishing, because at the end of it all, if you don't take care, it will just be. So we just have to make it loosely that it should be the need for people to report, but it shouldn't place an obligation. So for instance, if somebody reports at a public health, facility, and is going to be protected or be treated for an ailment or something, and is of the same sex, say it should be reported. That's the context. So we say that instead of making it mandatory, the heading should be report and prohibition of extrajudicial treatment.
Yep.
Yeah, extrajudicial treatment. That's what we came to.
Yes, so report and prohibition of extrajudicial treatment.
Yeah. And then it can.
In that case, the report is on extrajudicial treatment and not on any other commission of the offense. Yes. So if you say report and prohibition of extrajudicial,
so let me.
It will reflect the intent that we have here.
So because the possibility, the extrajudicial has to do with things that go beyond the law. That's what we are saying. So the possibility that people will just be reporting, anyhow, depending upon the context, can undermine whoever is having the mandate statutorily to deal with public health matters and other matters which has to do with access to services. That's the context. So maybe let's see what the rendition we gave.
So go to your rendition, let's see. Any report of the commission?
Any report of the commission of an offense under this act.
Are we doing 16.1?
Yes, 16.1. Offense under this act. It is not moved. First, shall be made to the police officer or in the absence of the police officer to a relevant authority of the community in which the offense is committed.
Yes. So we're going to have
to make it mandatory.
Yeah, we don't make it mandatory.
If we don't want to make it mandatory, then we can leave the rendition as it is and only substitute shall to may. A person who has knowledge that an offense is committed under this act may report the commission of an offense so that it doesn't become mandatory.
Yeah.
It becomes
I think the main is what we started earlier, that if somebody has a statutory duty to perform an obligation, like a public a medical officer, and somebody comes to the facility, because you say I have a duty to report, I will just go and say, oh, this person has come.
So that's why
I'm saying that it will be denied permissive. That protection or access to health. That is the context in which, because you say it's a duty. It's a duty. I don't know.
No, so because it's, I think we can recouch it to.
But Chairman, are certain relationships not protected? Doctor-patient, lawyer-client. Those are privileged conversations. So if someone appears in a health facility, the nurse, because they are offering, that's a patient of theirs, is not bound by this because they are bound by the doctor-patient privilege.
And it's only a court of law that can compel the person to disclose.
A health worker who, in the discharge of their function as a health worker, offers service to a person who is carrying out a prohibited act here, is carrying out a privileged relationship and cannot be said to be bound to do the reporting. It is only if a court of law requires of that person, because that's why I can go and confess to the Roman father that I stole. But he will not go and tell law enforcement that Sam came and confessed today that he stole.
Because it's privileged.
Because it's privileged conversation.
What about any ordinary person who is not the professional, but got to have information of what is happening in the health facility?
National security says, see something.
Say something.
Oh, but the person has come for public health reasons.
You are changing it again.
Oh, but you see, we have to keep the goalposts at one particular place. We're talking about provision of health and medical service, and it is not limited to the doctor. Every other person, from the reception to nurse to anesthesia, any other person along the value chain is included in the privilege. So it's not just the doctor. Same way when you go to see a lawyer, everybody in the chamber, including security, and there is a case law that suggests that everybody within the chamber who has interaction with the person is also protected. So we are talking about ordinary people who come upon that information, they stumble on that information, they have an obligation and a duty to report.
But it depends. If the person has come for health, reasons, the person has come for health reasons. That's the context in which we are looking at it.
Yes.
So, as for the professionals, it's clear.
Yes.
But someone says, "Oh, I've seen this person is going to the hospital. I've seen this armed robber is going to the hospital." Does it mean he won't be treated?
How would the person determine that the person is an LGBTQ, an armed robber, or a murderer or something? It's difficult to see. Unless, of course, there's some interaction or there's some confession. Otherwise, just walking into a health facility will not disclose the fact that you are going there for one purpose or the other. Please.
Thank you very much for the opportunity. I think the angle from which we are coming from is the fact that knowing that anybody in the health facility, apart from the nurse or doctor, may chance on my information and reports, I will not even go at all. And we are afraid of people who have issues with HIV and others hibernating because they have the phobia that when I go there, I don't know who will chance on my data or my information and make a report. And that's why we are saying that those exceptions may help. That the people know that if I enter a health facility, that health facility is not bound to report information concerning me so that I can access health care. So that's the angle from which we are looking at.
We are speaking the same language, I think. I think we are speaking the same language.
The same page.
Intimidated because
show up at all because anybody at all can chance on his information and make a report. So it will cause a lot of people to hibernate, and then the HIV issues will be going up, and because they won't access the facility to avoid being or something. So we are asking that the exceptions may help. The exceptions, they are not taking away the interment of the clause within the act. The position of the clause in the act will remain, but the exception is just to provide give assurances to people that when I go to this health facility, my information will not go. Or let's say I come to Stratch and I speak to someone and disclose who I am and all. Stratch is not bound, or even the law precludes Stratch to report me to a police officer. So
in other words, the proposal is that we create some new class of privileges. That's one. That one will be difficult because there is generally accepted, protection of privileged information. Exactly. So now you are saying that we should create new class of exemptions.
The ordinary person may not know this, and when they hear that they say anybody who knows about me should report. They would not show up at all. They won't show up, and that's why we are saying let's have it as a stand, but let's create exceptions. Yes, that's all.
And which categories are you? Can you give us an example?
Let me.
Shraj.
And so if someone comes to it and discloses his or her sexuality, they're not even permitted me from reporting. I'm supposed to offer myself.
Would the same apply if an armed robber comes to you? Do you have an obligation to report that this person is an armed robber?
I'm being beaten. I will even take upon myself to
No.
I'm saying that an armed robber has come to your office. Yes, that he's being beaten, and he has disclosed that, yes, indeed, I'm an armed robber. Do you have an obligation to report that armed robber?
My administrative justice role, I will speak to the police officer because the law does not permit me to deal with that. Yes, under administrative justice.
Mr. Chairman, for armed robber, he has been hit by a bullet. Runs, they didn't arrest him, runs to a hospital.
I think we have even agreed on the hospital bits. Now we are trying to include new class of privileges, and an example is being given as Shraj. And that's why I'm asking. So somebody has gone to murder somebody and has run to the office of Shraj to escape from a mob. To escape from a mob. Yeah, you may give the person some temporary protection.
Yes.
But you still have an obligation, isn't it? To report the murderer to law enforcement agencies.
I don't have an obligation under the law.
As a citizen.
Except that you are supposed to report felony. So in that context, yes. But under my mandate as Shraj, nothing forces me to go and make a report. No. Because I was there when.
Can I come in? I think because we're using words like privileges and the rest, the context in which we are talking about this is, and she mentioned it, eloquently. I have, because of the perception or the accusation that I am a gay, and if something is happening to me, I will not even approach a health facility at all. So that my right to health or my right to education, which is a human right, it has nothing to do with my status, whether I'm an armed robber or what, I'm a criminal. Even if you are convicted, you have rights. So this is the context in which we are trying to say that if you made it mandatory, people will even shy away from accessing basic services, which are rights, education, health, and all this, which are not privileges.
Thank you, Honorable Chair. I just wanted to mention that I think HIV, one of the reasons that maybe we keep mentioning it a lot is that there's no cure and no vaccine yet. And so really having people within the care network, whether in the health facilities or during our outreach, it's important to have that contact. But where people perceive that going to a health facility will lead to them being reported, it may lead to them shying away from the health facilities. And the effect of that will be going underground and then the infection continuing. So I think if that exception is created, even though I think Rankin mentioned that that privilege already exists elsewhere, but if it wouldn't hurt mentioning it here for the explicit exemption of health facilities or public health services, I think that would help. Or cross.
Basic services.
Thank you.
Yeah, Chair, I just want to mention here, when you look at patient charter, the right to disclose patient information to third party, by law, if you disclose it, the facility will be charged. The facility is guilty. So already there is existing law protecting patient, and the person going to a health facility is a patient. He's not going there as a victim of LGBTQ person. He's going there as what? Patient.
The reason why they're just saying that for purposes of clarity, if we can just make that exemption for purposes of health, people going to access healthcare, there's no point in adding them to this group.
Chairman, it may, I don't know, but it may actually be an unconstitutional provision to make.
Yes.
I'll read Article 41 for the benefit of the committee. Because the rights to healthcare and education are fundamental human rights. But this is what Article 41 of the Constitution says. The exercise and enjoyment of rights and freedoms is inseparable from the performance of duties and obligations. And accordingly, it shall be the duty of every citizen, A, to promote the prestige and good name of Ghana and respect the symbols of the nation, B, to uphold and defend its constitution and the law, C, to foster national unity and live in harmony with others, then D, to respect the rights, freedoms, and legitimate interest of others. But this is where it's important. And generally to refrain from doing acts detrimental to the welfare of other persons. It is the position of the sponsors that people who carry acts that are prescribed by this activity are carrying out actions that are against the welfare of others. 1. E, he says to work consensuously in his lawfully chosen occupation, to preserve and protect public property. G, to contribute to the well-being of the community where that citizen lives. So if the well-being of the community, what is the community standard? Our communities are not pro-LGBTQ. And so that's what I'm saying, that the enjoyment of your rights is within a certain framework. Those rights are not absolute. And then, because of the issue of Shraj, the Shraj Act is subservient to the Constitution. Article 41I says that you must share, you have a duty. It says you have a duty as a citizen to cooperate with lawful agencies in the maintenance of law and order. So if a law is passed that prohibits or prescribes a certain action, even though you are an officer of Shraj, the Constitution which superrides your Shraj Act mandates that if something that is against law and order comes to your knowledge, you must report that to lawful authority. So the Shraj Act does not, the Shraj Act, let's be clear, Shraj is not in a privileged position.
There are rights you cannot derogate from. Honorable, yes. There are rights you cannot derogate from, despite the session you read. Public health is linked to the right to life. They are non-derogable rights. You can't derogate from that.
So whether the person has committed a crime, whether the person has done ABCD, has to have access to health care.
And it's non-derogable. You can't take it away.
But this law says.
But there is no provision in this law stopping anybody that is stopping anyone from seeking access to health care. There is nothing in here. You see, let's not create that. Let me ask you, Chairman, when you are walking into a health facility, and all of us in this room have visited a health facility, at the entrance of the health facility in Ghana, they don't ask you what your sexual orientation is. So walking into a health facility has nothing to do with your sexual orientation, because there is no form you fill, even with the Ghana Health Service. If the Ghana Health Service is in this room, let's ask them if they have any form that they give to patients who are registering for the first time to state sexual orientation. No, there is nothing of that nature. A question of the person's orientation will only arise during the consultation with a health worker. And consultation with health workers are considered as privileged. And consultation with health workers happen in a consultation room, not in the general public, space of general public. So it will happen between the individual and the health caregiver. That health caregiver is in a privileged position, just like a doctor or a lawyer. So there is nothing in these processes that precludes whoever, irrespective of their orientation or proclivity. No, the health worker has a privileged conversation that we have established, that there are privileged conversations. patient doctor or patient healthcare giver, pastor, congregant, and lawyer and client. So those and then marital communications, those are established as privileged conversation. And so what we are saying here is, I don't see any nurse who treats an individual who in the course of consultation it comes out that whatever medical situation is as a result of the sexual orientation is not bound by clause 16 to report. There is no duty on that person to report because that person is in a privileged position. You understand the point you are making? However, the point that has been made here is that there may be somebody else in the health facility who will find out. And the point is, how will that person find out if they were not in a consultation room? Or if the nurse goes to tell a third party, that nurse is liable for a breach of the privilege conversation. And this one, as Minister for Communication, the Data Protection Act is clear. That nurse will be in breach of Data Protection Act, and so we cannot. The law cannot benefit from an act of illegality in breaching that right of the patient.
So, Minister.
Yes.
While we all appreciate this, and we think that it's one of the issues that has been raised. The initial inclination was to say that, look, is there any way, because health workers are directly working with, sick people, whether it's LGBTQ or whatever, is there any way you can put an exemption clause? However, for the interpretations and stuff that we have given here, unless otherwise, I think that health workers are exempt from this. But it will still not be fatal if we make a provision for an exemption and we specify health workers and maybe other related institutions that deal with health, sick people generally.
Mr. Chairman.
No, let me talk to listen to Kweku.
Thank you, Honorable Chair. The issue is whether or not, if we leave it in this current state, one, the health worker will be comfortable to, as it were, treat a patient who indulges in
the activities.
This activity. And second, whether or not, if we leave it in this state, the LGBTQ patient will feel comfortable to walk into any institution to seek medical attention.
Which is what we want to prevent.
That's the question.
There is some kind of solution in the draft bill. And if we look at regulation 17, clause 17, it says that the minister may, in consultation with the minister responsible for gender, children, and social protection and health, by an LI, make regulations: A, regulate and approve service provider, and B, provide for I, the support of victims of sexual activities prohibited under this act. II, assistance for intersex persons, and III, the effective and efficient implementation of this act. So the point I'm trying to make is that all these details that we are even asking for, we can consider them under a regulation and not necessarily put them in the acts, because these are matters which have already been provided for copiously under the Evidence Act. And so we can, when we are doing the regulation, look into more details on protection and provision of support services to persons who are victims. I think that we can go along this line. Just that we haven't got into clause 17 yet, but this is just
Chairman, I think that we can address this issue. I've just consulted with Senna and also with Shraj and Doc. The Evidence Act has some provisions on privileged conversations. So can we just introduce as it stands today, as it stands, 16.1 stands, and then we just add subject to the provisions of the Evidence Act, because then the Evidence Act stipulates all the kinds of privilege conversation.
Yeah.
So then that gives the kinds of protection. We can find that and the reference, whatever section of the Evidence Act, because just to provide some historical like background to this. The reason we actually, as sponsors, introduce this provision, and if you look at the clause 16, it's actually a protection for persons accused of being in the act, because we were trying to deal with the issue of extrajudicial treatment where people were accused and they were being lynched in communities. So if you go down in 16, you realize that there is punishment for anybody who verbally or physically assaults somebody on the allegation.
Yeah, or harass a person is there.
You understand me? So this whole thing must be viewed within the full construct of what 16 is. 16 is actually a protection of the fundamental human rights of every citizen who is accused or alleged to be engaged in one of the acts that is being prohibited here. But to make sure that people, if you say people should not beat the person, what should I do? Report the person to lawful authority. So that's where the duty to report came in from. Where we were saying that, look, if you do not put a limitation on extrajudicial treatment, people will continue the lynching. Now, if you say they shouldn't lynch, what should they do? Report. And that's why we said to relevant authority, and we've classified interpreted relevant authority to be the MP, a police officer, a chief, so that there is now no room for anybody who lynches somebody on the suspicion of being an LGBTQ person. You cannot say that you did not know. And that's why we've actually put punishment if you fail to report and go ahead to do extrajudicial. So this 16 is actually a protection for persons accused so that they have their day in court. Report them to the police and let that be established in a court of law. Because if you didn't do this, you would still have the law, and you could have instances where people were being beaten on the allegation.
Yes, but the flip side of it is when people get afraid to visit health centers because they think that there will be a report on them. So that's the area that we need to address. So
the subjection to the evidence.
Yes.
So what Honorable has just said, the scope of that. So we were proposing the headings to change report and prohibition of extrajudicial treatment. And from what the elucidation of Honorable, this is in sync with AU Resolution 275 and the Yogyakarta Principles, plus 10, which talks about violence against. So it is apt. But because of maybe the way it was couched, that's why we, after reading it, we said we should change it to report and prohibition of extrajudicial. And that's really a very good, Honorable, that's a very good provision. And it's consistent with the AU Resolution 275. And then the Yogyakarta Principles, yeah.
So we take it that once we reference the evidence decree or act, and then we will take care of the privileged information that health workers are supposed to have. Now, the fear of, victims walking into access healthcare will be minimized. Then we can now zoom on to, some judges, case, yes, of looking at it from the angle of the extrajudicial activities that may be meted out to the victims. So if we take it from that angle, do you still think that you want to change the head note?
Honorable, so I think...
Go ahead.
Based on the reading, we were bantering because we even were trying to protect the right to basic services, health, education, which will also be there. But the scope of this, that's why we even came to that con. And I'm saying that this particular provision, if we are able to, maintain it and change the heading, it will be consistent with international best practice and human rights standards.
Very well.
And because
what would you suggest? Do you want us to leave that for you
change the heading?
They just want us to delete duty
to report.
Yes. And say report
and prohibition of extrajudicial treatment. That would be okay. Then maybe the other leg is the issue about access to services, and maybe we don't know whether we have to create another sub. Because extrajudicial is extrajudicial.
No. So what we would do is, and you see, Chairman, we've had to walk a very tightrope as a private members bill, because in our original bill, after this was another provision that even provided funded medical care for persons and all of that. And then because of the financial implications, we had to withdraw anything. So that's why we said that after the law comes into force, the minister responsible for gender, children, and social protection will bring an LI to Parliament. At that time, the law will now be a law of the state and not a private member's bill. All of these introductions and all of these exemptions, if we want to even do institutional exemptions, can be stated in the LI, but not in the parent law. But you see, for anything to find expression in an LI, it must originate from the bill. And that's why we brought this protection framework here, so that it forms the basis for detailed protection in the LI that will follow suit. So, Chairman, I think that we can delete the duty to and leave it as report and prohibition of extrajudicial treatment, and then in 16(1) introduce at the end of offense is committed, subject to the provisions of the Evidence Act, and then we should be good to go.
Mr. Chairman, we can split this into two. We can split it into two.
We'll leave that one for the
one
to look at.
A duty to report, and then we'll have another one, prohibition of extrajudicial treatment. Then we can now use the part that deals with reporting will come under the reporting, and the part that deals with the extrajudicial treatment will come under it, for the avoidance of doubt. So, Senator, exactly. So let's split it.
We can still have it as well.
Let's split it in such a way that it will be clear.
It will be report. It will be reporting and prohibition of extrajudicial. We can still have it as one. Reporting and Senator, come.
Difficulty is that if we take out duty to, then it can read report of extrajudicial treatment. But we are not reporting extrajudicial treatment. We are reporting the commission of the offense.
No, it will be reporting and extrajudicial treatment, not report. A prohibition of extrajudicial.
So it will still be read reporting of extrajudicial treatment, and then prohibition of extrajudicial.
No, so prohibition of extrajudicial treatment and reporting. Yeah, you can get it this way, and the head note will still be fine.
And reporting what?
What Honorable Tampuli is suggesting will be a very elegant drafting, because we have noticed that there are two levels of this reporting. One, access to services, basic services, then also the one which deals with extrajudicial treatment. So we should be able to delineate. Then it makes it, neater for whoever. I think I'll go by Honorable Tampuli.
In which case, the prohibition of extrajudicial treatment will come first.
And that,
then reporting thereof.
Yeah, sure.
If we'll have to break it into two.
So it may change even the...
So then, Chairman, it means that, because if you read this, 16(1) and 2 deal with the duty to report.
Yeah.
Exactly.
Then 16(3) to 6 deal with the prohibition of extrajudicial treatment.
Yeah.
So then it means that if we are going to break it, we will have prohibition of extrajudicial treatment.
That's right.
At 16 with 3, 4, 5, 6 now becoming 1, 2, 3, 4.
Yeah.
Then we will have a new clause 17 that will read duty to report, and that will have clause 1 and 2 as they sit now under 16 as the 17 1 and 2.
Yeah, because right now
So
the confusion is in the head.
prohibition will be 3, 4, 5, and 6. And then 1 and 2 will be
under duty to report.
To report.
We're good? Absolutely.
Okay, I'm sure as Commissioner in charge, I think we are good to go with this. Yeah. So there's no victim who should fear going to the assessing services, because that is not part of that's not the type of reporting. That's not the type of reporting this bill envisages. Yeah. So, ladies and gentlemen, honorable members, any indication? We are in your hands.
Tomorrow. Mr. Chairman, I move.
Sorry. We'll come at 11 tomorrow, not 9.
Oh no, 10 o'clock. 10 o'clock. We'll come at
Mr. Chairman,
we'll come at 10. Close.
I beg to move.
We'll come at 10. We'll start at 10. Of course, you say like the 9, but we also start at 10. And then we'll close at 12. We will go for prayers and come back. We will still be here. Not to justify why we
Mr. Chairman, on this note, I beg to move that the consideration of the bill be adjourned till 9 or 10 o'clock tomorrow. I so move, Mr. Chairman.
Yes, you have moved, and I don't need a seconder.
I second the motion.
Motion moved and seconded. So we are adjourning, but we are suspending, because the quorum we started today will be the quorum till we leave here.
We'll finish.
And so we reconvene tomorrow. Yes, we reconvene tomorrow at 9 o'clock. No, at 9 o'clock. I so move.